Good morning to those who have decided to participate with us. We welcome you. This is the Colorado Oil and Gas Conservation Commission. It is May 10th. This is our weekly business agenda. We will start with a roll call.
Thank you, Mr. Chair. Commissioner Ackerman, Commissioner Cross,
Present.
Commissioner McGowan, Commissioner Mesner,
Here.
Commissioner Oath, Commissioner Ray,
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 4 out of 7 commissioners present.
Great. And that is a quorum. Good to see everybody. We will start with our agenda that has been published. And the first thing on our agenda is commissioner comments. Does any commissioner have comments? All right. Seeing none, we will move to public comment. We had one person that signed up for public comment, Scott Sallow, and I see that he's in the hearing as an attendee. If we could raise him to the panel.
So Mr. Sallow declined my request to become a panelist. Mr. Sallow, if you would like to still speak, I'll make that request again for you to become a panelist. And if you could accept that, then we'll be able to hear your public comment. Looks like he's coming in.
I see we have Mr. Sallow as a panelist. If you would like to unmute yourself, we would love to hear from you.
Sorry, did that work?
Yep, we can hear you now.
Okay. Would you like, is it okay if I speak now, sir?
Yes, sir. We're waiting to hear from you. Go for it.
My name is Scott Salo. I'm the owner of Salt Ranch, a 7,000 acre cattle ranch in northern Weld County. I've always been a strong supporter of the oil and gas industry, but after what they've done to my ranch, I understand that far more must be done to regulate the industry. I'm here to ask for you to enforce your rules to help me to protect my ranch. More than 5 years ago, I entered into a surface use agreement with Clear Creek Resource Partners. They were a great company to work with and did everything they promised. We've had to work with 5 energy companies over the years and not so much as a crossword with any of them. Unfortunately, they sold their interest in my property to Upland Exploration. Upland has drilled 2 wells on my property and 4 wells on the property to the east of mine. In short, since Upland started to drill, I've had to fight every day to protect my family, my cattle, and my property. In 5 minutes, I cannot tell you everything that they have done to my property, but I'll try to give you a short summary. The roads have been an ongoing problem. Clear Creek created a 5.6-mile road across our property to access the well pad. They followed a good general construction and oil field practices by surveying the outside edge, removing and stockpiling topsoil, building the road surface, and placing topsoil to reclaim the ditches. The previous operators also diligently sprayed weeds and placed appropriate rock erosion dams. The road ditches were in fact completely sodden and had very few weeds emerging annually because of the responsible previous operators. Then Upland took over and stopped any weed control measures. Weeds took over next to the road. While Upland was snow plowing this winter with a bulldozer, most of the gravel road and all of the rock erosion dams and sodden ditches were scraped up and thrown as far as 40 feet into our pasture. They then took a road grader into our pasture in an attempt to pull back all the road materials and ditch material. In the process, they cut the topsoil off the pasture and incorporated it into the road. In an attempt to cover up the damage and road materials on the pasture, they cut new ditches with no survey of the outside of the right-of-way on one or both sides of more than 3.7 miles of the existing road. In doing so, they incorporated the topsoil into the road. They did this without permission and without a survey. What they left behind is a road that is far wider than it needs to be, with all the gravel in the pasture and sediment running off the road every time it rains. Because there's no gravel on the road, the wind blows the topsoil road every day. Dust rolls off the trucks when they go through, even if they are going the speed limit, which is rare. The last contractor I stopped was going 47 miles an hour. It took me 2 miles to stop them, and it's through our livestock. The property damage is dramatic. They've destroyed more than a dozen acres with their road grading. In more than 50 locations, employees and contractors have, and they still continue. Can you hear me still?
Yes, we can.
Sorry, my phone doesn't show you, sorry. In more than 50 locations, employees and contractors have and continue to drive off the lease road, turning around in our pastures, damaging and in fact killing the grass in places. Weeds have been a huge problem. The 1.5 miles of newer lease road has 20 to 40 feet of solid weeds: kochia, thistle, cockleburrs, sandburrs, and puncture vine. There's more than 7 acres, closer to 8, of weeds on my property as a result of upland. To put it in perspective for you, that's 6 football fields of solid weeds. We asked Upland to remove the weeds, but the only time they sent contractors out to remove weeds is when they knew COGCC inspectors would be present. The fence lines are now full of weeds from the high wind blowing them free. We are adjacent to the national grasslands, which will now also be dealing with increased weed pressure for the foreseeable future because of upland. Because of the weed infestation, we were not able to graze cattle on 960 acres. We typically put 320 steers on those 960 acres, or 1 head per 3 acres, for 20 to 30 days of the month of April, depending upon leftover forage and emerging cool season grasses. This particular pasture, we only used 11 days last year. Instead of grazing, we've been forced to feed hay, 14 loads, in order to supplement them because of our inability to follow our usual grazing procedures. Historically, we have never fed more than 3 or 4 days in a spring snowstorm event. The 14 loads of hay will have to be replaced, and at today's all-time hay prices, the replacement cost us is over $150,000. For 9 months, they've had an open roll-off dumpster with no lid or containment in our high wind area. They've coated our ranch with every piece of trash imaginable. The road through their time on us is constantly full of trash as well. We have tried everything to effect changes prior to bringing this to COGCC. Your environmental inspectors, Chris Benches and Denise Arthur, have been very helpful and supportive. On February 10th, they cited Upland for 13 NOA VSs on my property and another 10 NOA VSs on the well pad adjacent to my property. They've been out several times and I appreciate their support, but nothing changes. They agree that most of the violations have not been corrected, but there's no enforcement, there's no fines, there's no hearing date, there's not an enforcement officer assigned to this case after 4 months. I'm just asking for your assistance. I'm running out of options. I've locked Upland out twice after I caught them driving cross country across the ranch. The Weld County Sheriff has been called out and tells me I have the right to shut them out if they're trespassing, but I let them back in to get the produced water and oil tanks empty. All I ask is that you enforce your rules, and I'm happy to answer any questions.
All right, thank you very much, Mr. Salo. My understanding is that there are some outstanding notice of alleged violations with our hearings officers. I'm pleased to hear that Ms. Arthur or Dr. Arthur has been able to get out there and take a look. I also understand that you were, well represented with an attorney. Some of that lies with us, and I want our staff to be responsive. Some of that lies with the surface use agreement you have, which is a civil matter. I hope that the COGCC continues to be responsive to complaints that you've made, and would direct you to Deputy Director Scott Cuthbertson if you have further issues with regard to matters involving the commission. But want to thank you for bringing that to our attention, and I'm pleased to know that our staff is trying to be as responsive as they can on the elements of the concerns that lie within the jurisdiction of the Colorado Oil and Gas Conservation Commission. All right.
Thank you.
You are welcome, and please don't feel afraid to come talk to us. The commissioners aren't really in a spot to be able to sort of respond to allegations, because ultimately those things make their way up to us in the form of the enforcement. But we can direct you to the right people and are happy to try to do so, and wish you all the best with your farm and with your interrelationships with the new company Upland. And hopefully Upland was listening in today. All right, with that, we will move to our next matter on our agenda, which is consent agenda. Does any commissioner have any questions with regard to consent? Seeing no questions, do we have a motion to approve consent?
So moved. Second.
Motion and a second to approve consent agenda. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Consent agenda carries. We will now move to our first docket. That is docket number 2212-00342, involving a financial assurance plan for Vision Energy LLC. And I believe we will recognize Mr. Willis as attorney for Vision Energy for a 20-minute presentation.
Good morning, Chairman Robbins. My name is Rob Willis. Can you hear me okay?
Yes, we can.
Great, thank you. I represent Vision Energy today. I'm a lawyer at Post Nodell Peterson Law Firm. I'd expected the sun to be out here in Denver today, given the Nuggets win last night, but I was disappointed. But that doesn't mean that we can't pursue additional victories down the road. I've got a witness that I need to at least make sure is on as a panelist. He's going to be providing evidence today and comments in support of the application which has been filed. His name is Mickey O'Hare. He's managing member of Vision Energy. And I also have another potential witness who is listening in today, I believe, and probably will be on as a panelist. I see Miss Larson came on. Miss Larson.
I was just wondering, could Mr. O'Hare please raise his hand? I'm not seeing him. Your panelists or your witnesses should be in now.
Okay, and the second witness that I've endorsed is Trish Harrison. She's an employee of EIS Environmental and Permitting Services. She helps and is responsible for Vision Energy's permitting and regulatory compliance. Basically, she's very integral in that. I expect her to be on an as-call basis, and she may be providing flavor or some answers as required. What I'd like to do is just kind of orient you briefly with Vision Energy's operations. Vision Energy operates 108 gas wells in Colorado's Piceance Basin, a variety of counties. 94 of those wells are subject to federal bonding requirements, which leaves 14 wells subject to Rule 702. If I could ask Ms. Amaro to put up the hearing presentation, just a series of 5 slides. This is a list of those wells, which are subject to 702 requirements. 4 of those wells are non-active low producing wells and are covered by the option to blanket financial assurance coverage requirement. 10 are not. Next slide. Option 2 authorizes 5% of operators' total number of wells operated. In this case, there are 108 wells. 5% of that yields 5.4%. My request, and Vision Energy's request, is that the count for the number of eligible wells for increased blanket for coverage would be 6 wells versus what the director's recommendation or notice of decision sets forth as 5 wells. If doing so, the next slide, please. There's the 10. Let's go to the next one again. I'm sorry. Thank you. If we take out 6 wells from the equation, inactive low producing wells, that yields 4 wells, which are subject to single well financial assurance obligations. 10 wells under the financial assurance option to blanket at $15,000 for the 108 wells operated yields an obligation of $150,000 under the blanket financial assurance piece. In looking at this particular slide, you'll notice that it includes the Rifle Bolton #1 well. This well has been brought to your attention recently. In February of this year, enforcement, it wasn't really enforcement, it was the director brought an application to you requiring that the Rifle Bolton 1 well, which is also part of a compliance schedule, which is being worked diligently by Vision Energy under order number 1303, is part of that compliance schedule. It's also part of this list. We ask that you exclude this from single well financial assurance. And the reason being is there's a requirement under order 303 that well be plugged on or before June 15th of this summer. And that is going to occur. I've been assured by my client that monies will be better utilized, any monies which might be attributable towards financial assurance would be wasted, in so much that that well would have plugging operations starting by June 15th and efforts made towards closing the location at that time. Now that yields 3 wells, which would be subject to financial assurance. I'm sorry, single well financial assurance obligations. Vision Energy asserts that the $30,000 presumptive plugging and abandonment costs are supportable with information and costs that they have borne through their compliance with the 1V609 compliance schedule order. However, the $100,000 reclamation costs are both unnecessary and unreasonable. And Mr. O'Hare should provide information to you, I believe, which will at least give rise to demonstrated costs that you can deliberate on as to what the appropriate reclamation component of single well financial assurance should be for these 3 remaining wells subject to financial assurance under SWFA. Rule 703, there are no other oil and gas facilities currently operated or opened by Vision Energy, so no bond is required there. Rule 704, my client asserts that there's no surface owner protection required at this time. They are ensuring through an internal audit that they have surface use agreements in place for all impacts to surface owners. That's my presentation. I appreciate you listening to it. I'd like to now call Mickey O'Hare for a brief narrative.
Can you hear me, commissioners?
Yeah, Mr. O'Hare, before you go into any testimony, let's bring up Attorney General Davenport to get you sworn in.
Thank you, Chair. Mr. O'Hare, there you are, sir. Thank you. Would you raise your right hand, state your name, and say that you swear to tell the truth, please?
My name is Mickey O'Hare, and I swear to tell the truth.
Thank you, sir.
All right, Mr. O'Hare, the floor is yours.
Thank you, commissioners. Just to give you a little bit of background, I've been in the oil and gas industry for more than 40 years. I'm a petroleum engineer by education, have a Bachelor of Science degree from New Mexico Tech. I've been a registered professional engineer for more than 35 years. I've testified in front of the Oil and Gas Conservation Commission on a number of occasions and been certified as an expert witness, both in Colorado and in New Mexico. Vision Energy took over operations and ownership of the wells that were previously operated by Merrill-X Resources in the Piceance Basin on January 1st of 2020. We have been, since that time, plugging and abandoning and MITing wells under a schedule with the COGCC and the BLM. Last year, we accomplished a total of 27 P&As and MITs. This year, we're scheduled to do a minimum of 24. We've exceeded the number of wells on the schedule under order number 609 every year that we have been operating the wells there in the Piceance Basin. I spoke to our rig company this morning in our Rifle Bolton #1 well. We're scheduled to have the rig head up there Friday morning, and we're hoping to start the plugging operations on that well on Saturday of this week and hope to have it completed by the end of next week. The deadline, as Mr. Willis indicated, is June 15th. So we expect to meet that or beat that by close to a month. As far as the reclamation costs go, we have experienced reclamation costs primarily on federal lands. We have very few reclamation costs on fee lands because we've been focusing our efforts on meeting our obligations on the MITs and P&As on the federal wells. But those costs have ranged from a low of less than $2,000 to a high on one well of $115,000. That $115,000 was actually incurred because of changes in the requirements by the BLM after the work had been completed. And we had to go back and basically redo that reclamation on that one well. On average, our reclamation costs, and again, this is on federal lands, and I'll give you the difference on those here in just a minute, but the average costs are somewhere in the range of $20,000 to $30,000 reclamation per well. Now, the big difference to us is that mostly private landowners are more than happy to keep a flat surface rather than having us recontour back to the original contours. Most of the surface owners want to use that flat surface for things like installing barns, for storage of equipment, farm and tractor equipment, trailers, even hay storage. So many of them do not require us to reclaim the land to the original contours because they want that flat surface. Most of them also require that we leave the rock and gravel in place on that surface because it gives them a firm pad to be able to utilize for their operations, their farming and ranching operations. The only time that they require that we remove that gravel and rock is when it is in the middle of a producing field. And generally, even then, once we remove the rock and gravel, they'll go back and plow and disc and float and plant the land themselves, and we'll compensate them for that work. But generally speaking, it's just an acre to an acre and a half in size, and the cost to do that work is almost always less than $5,000 for the farming part of it. The majority of the cost comes in the removing of the gravel and the rock, and that can be up to $15,000. So we think that a more reasonable number for the reclamation on a per well basis is going to be more in the range of 20 to 30,000. 25 would be more than acceptable to us, and that's what we're recommending for a reasonable charge for bonding of those remaining 3 wells on an individual basis.
Mr. O'Hare, I'm sorry, we had a conversation yesterday regarding the bonding market. I'm wondering if you might give the commissioners some flavor as to what you've experienced in the surety bonding market recently.
Recently, we've been hit with a number of additional bonds from the BLM, the state, and the county. And the bonding market has tightened up considerably. We have been requesting bonds for the BLM right-of-ways that have been transferred to Vision Energy, and those bonds have not come through. We're talking about months, a minimum of 6 months of requesting those bonds, and we still don't have an approved surety bond on any of those right-of-ways. The Plata County recently increased or decided that their Rule 90s financial assurance needed all operators needed to be bonded at $175,000 per operator. We are currently working with our bonding agent to try to get that bond in place. And again, there's a very slow response to our request for bonding.
I appreciate those remarks. Is it your position then, as you sit here today, that it's very important to your operation that if you have an obligation under the state rules to bond up, especially when it comes to single well financial assurance and the assessment that is being levied against your operation, and respecting that the commission is doing so on a basically on a cash, or not a cash basis, but a dollar for dollar basis for what the single well obligation would be, that the obligation reflect what your actual or anticipated costs for reclamation are, at least, so you're not wasting money or perhaps not able to cover with a bond, which may not be available because of those increased amounts of up to $100,000.
Yes, it is. And we're also requesting that there be additional time allotted for us to get those bonds in place.
I don't have any further questions for you. The commissioners may, so I'll just defer to Chairman Robbins.
All right, commissioners, are there questions for the witness? That was a tie. I'll go with Commissioner Cross just because I could see him a little bit easier. Then we'll go with Commissioner Messner.
Thank you, Mr. Chair, and thank you for your presentation this morning, Mr. O'Hare. I just wanted to ask a couple quick questions. You talked about some of the average cost you're seeing. Do you have any documentation to support the costs? What went into the costs of doing this reclamation that you discussed here, talking about your recommendation for 25,000?
We don't have that available at hand right now, but I can dig up some of those costs, yes.
Okay. And could you explain a little bit, you talked about the additional bonding costs right now. Can you explain a little bit what you have currently in bonding for financial assurance purposes?
Yeah, we have just under $3 million currently with the BLM in plugging and surface bonds. They're requesting another $440,000 in bonding for those right-of-ways, both pipeline right-of-ways and road right-of-ways. As I mentioned before, the $175,000 is a new bond from the county. We have, I want to say, roughly $250,000 in bonds with the state of Colorado, the COGCC, both surface and plugging bonds. So in total, we have well over $3 million in bonds.
And currently, do you have any ongoing issues with respect to outstanding NOAVs or inspection issues, any outstanding MITs or brainhead tests or anything of the sort?
Yes, we are behind on our Bradenhead tests. We were not able to complete all of those last year. We are working hard to get those up to date this year. And we are still, as I mentioned before, trying to complete our Order 609 MIT compliance, MIT and P&A compliance. We have an obligation to do a minimum of 24 wells this year. We've actually scheduled 30 to get done before the end of the year.
That's the only questions I have for right now, Mr. Chair.
Commissioner Messner.
Thank you, Mr. Chair. Commissioner Cross asked a number of the questions that I was going to ask. But Mr. O'Hare, I noticed that your name on your Zoom picture indicates Marilex, and I guess I wonder if you could talk to me a little bit about the relationships between Vision and Marilex corporations.
Yeah, Marilex Resources is a family-owned business. My wife and I own 50% each of that business. Vision Energy has different ownership. Marilex is a majority owner of Vision Energy, but it has other outside owners as well. So Marilex provides much of the field operations and supervision of the rig work for Vision Energy. So it's basically a contract operator for Vision Energy, but Vision Energy has different ownership from Marilex.
Okay. And you indicated that there was a number of wells that have been P&A that final reclamation hasn't been accomplished on, and that the majority of those were on federal lands or federal leases. I wonder if you could indicate how many of those 25 wells that have been P&A'd that have not received final reclamation are not on federal lands or federal leases.
Yeah, the federal leases, I believe pretty much all of those wells are on federal leases. Some of them are on private land, private surface. And I think at least 2 or 3 of those are on private surface. and pretty much the rest of them are on federal.
Okay. Mr. Chair, those are the questions I have at this point.
Okay, thank the witness for the Q&A. Mr. Willis, did you have anything further in your case in chief?
I do not.
Okay. Then I think that we should recognize our staff for a presentation. I believe we're going to hear from Scott Cuthbertson.
Thank you, Chair. My presentation will also be pretty brief. I just want to review the director's recommendation that was filed in this case. And I'll share my screen to just go through 3 or 4 slides to give us a sort of a visual roadmap here, if that's okay. So you should be seeing a summary of the Vision Energy wells that are subject to Rule 702.
Yep, got it.
So this is to speak to some of the information that's been provided. This is the summary that was correct at the time that the Form 3 was filed. Just to remind commissioners, you know, the process of an application for a financial assurance plan, that's how we treat the Form 3, looks at the it's very data driven, right? The financial assurance plan is driven by the data associated with the operator for the preceding 12 months before the application is filed, before the Form 3 is filed. And so in order to do that, we freeze that data. When the Form 3 is initiated, we look back and we pick the 12-month period that we have the information for that operator, and we freeze that data. And so this is the data that was correct at the time the Form 3 was filed. You heard Mr. Willis comment that they have 108 wells. I can corroborate that. Today they only have 108 wells because they have plugged 10 that were on this list from October when this form was created. The really important thing here, though, is that as Mr. Willis indicated, only 14 of their current wells are currently subject to Rule 702. In this case, 104, but now today 94 wells, as Mr. Willis presented, are enjoying the exemption of the federal exemption that expires in October. So when October is done in November, this will be one of the operators that we will be reevaluating to determine what their Rule 702 financial assurance requirements are as we evaluate the federal financial assurance that they have with the Bureau of Land, with BLM, and determine whether additional financial assurance is required to meet the COGCC rules. So just wanted to kind of provide that as a background. You heard testimony regarding reclamation costs of $25,000. And I would just say that the director's recommendation recommended not accepting the operator's request for an option 5 plan due solely for the lack of foundation. We did not see any supporting documentation or information in the application that could support the costs that the operator was proposing as the foundation for their financial well assurance, for their financial assurance for their Rule 702 wells. This is the table of proposed per well financial assurance that the operator included in their option 5 application. This is for Rule 702. So it's plugging, abandonment, and reclamation. And you can see they're proposing just over $7,000 per well for their 14 wells to get to the $100,000 of total financial assurance that they're recommending, which just coincidentally is the amount of financial assurance they have on file with us today. So I don't see these numbers reflect the 25,000 reclamation costs, to be specific. This is to just summarize the option. This is what the option 5 financial assurance would be if you approve the option 5 plan request. And this would be due within 90 days of a commission order pursuant to the rules, absent some variance that you would provide the operator. The director's recommendation also recommended it. So every Form 3, every financial assurance plan that's submitted, the operator qualifies for one of 4 options, option 1, 2, 3, or 4, based on their 12 months average per well production and the number of wells that they have subject to the rules. So every option 5 plan that you will hear has an alternative plan that the operator rejected as they requested the option 5. They could have requested the option 1, 2, 3, or 4 plan, or they could request an option 5 plan. The option 2 plan that the operator rejected in their Form 3 that was submitted would have required this amount of financial assurance. At the time that the operator submitted their Form 3, their previous 12 months average daily well production qualified them for an option 2 plan, which would require this amount of $468,000 to be due within 90 days. Now let me speak to the 100,000 Rule 704, because you heard information from Mr. O'Hare regarding that. The data in the Form 3 is driven by the data that the operator has submitted to us. There are provisions to submit out of service forms that would exclude wells from the requirement for financial assurance. There are, previously the operator, if they did not need a surface bond, we have long had the ability for them to file the surface use agreements that demonstrate that they don't need surface owner bond protection. If you'll remember, surface owner protection is not required if the surface owner is part of the mineral ownership, if the operator has a surface use agreement, and there's one more that slipped my mind. So there are ways for the operator to submit information to inform COGCC that they do not require a surface owner bond, and we will certainly take that into consideration as we process the Form 3. So the operator has the opportunity to submit that information and submit a revised Form 3 to correct that. So the number I want to focus on is the Rule 702. So the Rule 702 for the option 2 plan as submitted would be $368,000. Now I need to also just bring your attention quickly to an error that was made in the director's recommendation. We errantly included a wrong exhibit document that suggested this number was significantly more based on just hitting the wrong button. And I apologize for that. I did that. I take full responsibility for it, and I will need to file a revised director recommendation. I did not see the error until yesterday when I began to prepare for today's testimony. But this is the option 2 amounts in the submitted Form 3. I will just also, for comparison's sake, show you the difference between the option 5 plan the operator requested and the option 2 plan that they qualified for at the time that they submitted the Form 3. I will make one more quick observation. The rules identify 2 kinds of plans: an initial financial assurance plan, which is the plan that we're considering today, and a revised financial assurance plan. A revised financial assurance plan is subsequent to once an initial plan is approved, obviously. So once an initial plan is approved, then the rules provide direction regarding how to file revised plans. A revised plan is required by the operator when the operator becomes aware of a change in circumstance that they know in their understanding of the rules requires a different financial assurance plan. So a revised plan is required when the operator becomes aware of a change in circumstance. The operator is directed to file a revised plan. A revised plan is also required when the director does a review, which the director has to do at least once a year, at least one annual review. If in that annual review, the director finds that the operator no longer qualifies for the plan that they currently have, or that there is a change in circumstance that the operator failed to notify, or some other condition, compliance conditions, a number of factors that the rules direct the director to take in regard to that annual review. So in this case, in our processing of these plans, we are restricting our analysis to the initial plan submitted. But I would just bring to your awareness that if we had an initial plan already approved, and we were to do our annual review today, this is what the operator would qualify for today. They would qualify for an option 3 plan that would require this amount of $92,000 to be due within 90 days. And that's 5% of the total associated with that plan that they would qualify for today. Now, this is not a matter for this hearing in my perspective, other than whatever you feel like but I wanted to make you aware that these things will change in the future. So this operator is going to be subject to a federal exemption review pretty quickly, as well as an annual review. And I'm stuck here trying to stop sharing my screen. So let me.
Actually, keep your screen share up there.
Oh, okay.
Deputy Director Cuthbertson. Couple
And
of
that concludes my prepared comments, Chair.
Yeah, that's kind of what I thought. So a couple quick comments. So we should disregard this slide and this option 3. Is that what you're saying? It
is not, in my perspective, the subject for today's hearing. Yes, sir. But okay. I wanted to, I just wanted to make you aware of the administrative process that these plans are doing, since we're fresh out of the gate in this financial assurance plan consideration.
Okay, and then a second follow-up question. On the slide that we're looking at now, under option 2, under Rule 702, the director's recommendation is the 368 number, the 368,000, or is that right?
Yes, sir. That's for the 14 wells that are subject to Rule 702 at the time of this application.
And then we should, again, and you noted the error, but the director's recommendation had that number at 785.
Yes, sir.
And that is in error. And so from our deliberative perspective, we should be looking at the 368.
Yes, sir.
Okay. And then finally, with regard to Rule 704, just to confirm, your testimony is that the operator did not provide any foundational evidence to qualify for any of the surface owner protection exemptions. Is that accurate?
Yes, sir.
Okay. Further questions from commissioners at this point? Commissioner Messner.
Thank you, Mr. Chair. Thank you, Mr. Cuthbertson, for being here. I am going to need you to work through some math with me here, because, you know, in evaluating the number that you had in the director's recommendation, it seemed accurate to me in the sense that it did contemplate single well financial assurance for a certain number of low producing wells. And I'm trying to understand in this new number where the single well financial assurance associated with low producing wells is being calculated, because it does not seem to calculate. I mean, my understanding at least, and I'll go back to my notes here, and I believe that there were 5 single well financial, or 5 low producing wells after your anticipated reduction due to the percentage exempt that should have single well financial assurance associated with them at a minimum of, I believe, $120,000 per well. And so I'm trying to understand how we got to 368 instead of the 768.
And I don't have a good answer for you, Commissioner Messner, except that these are the numbers from the form as submitted by the operator in October. Obviously, I was prompted in my director's recommendation to present different numbers, and I used the wrong foundation for it. I regret that error, and so I don't have a good foundation to defend it. The number of low producing wells that exceed the 5% allowance for the per well would require, I believe it's $115,000 per well, if my memory serves me correctly. And so there's anomalies here that I cannot explain to you today. I apologize for that.
Okay, well, I do think that that's going to have to be addressed before at least this commissioner is able to make a determination on this particular application. The other question I have is kind of application of the 5% exemption associated with option 2 plans, understanding that this operator at the time of the application had 114 wells, and but only 14 wells are actually being contemplated in this particular application because of the federal exemption up until October of this year. But yet we're applying that 5% exemption only to the number of wells in this application rather than across the entire spectrum of the wells that are being that the operator owns, right? And so, for example, if there's 114 wells, I mean, arguably somewhere between 5 and 6 wells would be exempt, rather than taking these 14 wells and exempting one of them from single well financial assurance. We're choosing to exempt 5 of them from this particular application rather than taking the one and then perhaps exempting the other 4 or 5 once we're reviewing the financial assurance in October. And so I did have a little heartburn from that, because it doesn't seem to make sense to me to take all of the exemptions in this particular application, but rather proportionately take the 5% exemptions from the 14 wells that are being applied here, which ultimately have 10 low producing wells. And so even rounding up, that would be 1 well that would be exempted in this particular application, and therefore leaving 9 wells that would require single well financial assurance in this particular application. And then the other exemptions would be applied to a future application that would happen after October of this year. Does that make sense? I guess I'm just trying to understand that.
Yes, and I can respond if you'd like.
Of course.
So the implementation of the 5% allowance that we chose to program into the process was based on our understanding of the Statement of Basis and Purpose Directive and other testimony that was provided in that portion of the debate. And we consulted with the Attorney General's office to review that testimony to try to determine what we felt like the intent of the debate and deliberation was. And what we concluded in that analysis was that there was a clear indication that there was an expectation that the 5% for an option 2 allowance would be based on the operator's entire well set, because to do otherwise, we would have to just completely recalculate everything in 12 months' time once the October exemption expired. And that those, that allowance would apply to whatever wells were then subject to Rule 702. And so we didn't find any foundation to limit the number of wells to some proportional amount of the current Rule 702 wells. And so that's why we allowed the entire number of wells. We did round down, as Mr. Willis indicated. We did not round up. 5.4 wells is 5 wells. You can't have a 0.4 of a well. And so we did round down to the nearest whole number of wells that would be afforded the allowance to be included in the per well blanket assurance amount for the option 2. And then we did not adjust that number beyond that. The second reason for that I already alluded to is that we knew that wells that were in this category were subject to an exemption that was expiring in October of this year, and that the opportunity to review those operators' plans would be afforded us very quickly. So rather than try and change what we felt like the deliberative intent of the rule here, the rule testimony was, that we implemented it in the way we did.
Okay. Mr. Chair, just I just wanted to indicate that I would request at the appropriate time an executive session on this topic.
Sounds good. Let's exhaust commissioner questions before we jump into that at this point. Further questions from commissioners? Okay, seeing no further questions, Mr. Willis, I would recognize you and or your witness for any rebuttal statements or summary of position now that you've heard from the director.
Yes, I appreciate that. I'm not certain whether my client wants to say anything, but I'm just going to lead in with at least my conclusory remarks. And I'm troubled. I've spent weeks trying to understand what was going on with the director's recommendation, and I thought I understood it when I sat down to talk to you today. I like Mr. Cuthbertson. I don't think there's any ill will here at all. And he's worked with me beautifully in not this case, but other cases. But I haven't seen those slides that he showed you. I'm looking at the original director's recommendation, which apparently had some errors in it. And I built my presentation today based on that. And my understanding of the rules as staff was putting them in practice based on this document. And I haven't seen any of the other stuff. I mean, the other slides come up with all these other numbers that I'm not privy to. And that troubles me. And I think that that's not how the commission needs to address their affairs under the rules. The rules are supposed to be clear and concise. They're not to be applied in an arbitrary and capricious manner. And I'm going to just submit to you that I think that's what I'm seeing here is staff having a difficult time understanding how to roll these rules out. How is the regulated community to understand the complexity of these rules? And then a slide is thrown up, which I think is to besmirch my client's ability to work the Form 3 in the first place by indicating that they're putting in a low amount of single well financial assurance based on their ability to work through the rules and the form. And I just am trying to catch up to the process here, which once again I thought I understood before you called the case today. And now I don't know what's going on. And I need to get together with my client to talk about what this new information is. I mean, some of these figures I think would be palatable to my client, but I'm not, especially when he throws up that last slide, which has a 1.8 obligation under an option 3. That's news to me. I've not seen anything in that regard, so I can't even respond to that. So anyway, those are my remarks, Chair, and I appreciate you allowing me to go on the record with those. And I'm going to ask my client if you're going to allow him to talk to anything that he's heard with regards to the deliberations, as he tries to run his business.
Mr. O'Hare?
Yes, thank you, Mr. Chairman. And I just have to reiterate what Mr. Willis stated. We've been struggling to understand the rules from day one, and we still don't think we have a good handle on what our obligations are under the financial assurance rules, especially with the different options there. Obviously, we're trying to find what is best for us, what will enable us to continue to operate our wells in Colorado in a professional but efficient and profitable manner, so that we're not sitting here just plugging wells that may have some upside potential, and that we're not prematurely abandoning wells because of the extra costs that we're incurring on the bonding side or the financial assurance side. So we would love to get more instruction and information as to what our obligations are and what's the best way for us to meet those obligations under the financial assurance rules. Thank you.
Okay, couple of thoughts for commissioners. AG Davenport, if you would visualize yourself, I'd appreciate that as well. We've had one commissioner indicate that prior to deliberation, there's a suggestion for an executive session. We're in a bit of a bind. In order to go into executive session, we would need the affirmative vote of 5 voting commissioners. We only have 3 here today, so we're not in a place to be able to go into executive session. A second thought from at least this commissioner is it appears that, and again, I appreciate everybody sort of noting no ill will on anybody's part, and this is a new paradigm with regard to financial assurance, and we want to make sure that everybody, understands the rules and that we apply them accurately and not arbitrarily and capriciously. Understand that there had been an error in the director's report and new information was generated today with slides, which is fine. I'm wondering, though, if given the lack of an ability to have an executive session and given this new information, if perhaps a continuance of the matter to allow the applicant and the director to have further discussion would make some sense. And then that also would give us the ability to, when we do take this matter up under a deliberative phase, if we do feel like there's a need for legal advice, we could obtain that in an executive session. So I sort of throw that out there for everyone to contemplate. Mr. Willis, I would wonder your thoughts about that concept as far as a moving forward stance.
Well, thank you, Chair. I certainly feel that it would be inappropriate for the commission to deliberate on this, given the state of the record today. I'm confused. I know my client is confused as to how these rules are to be manipulated and or brought forward or enforced by the agency. I certainly benefit for continuing conversations, though I haven't had any with Director Cuthbertson for this operator, but I would like to talk to him about where this is heading and what is going on as I try to wrap myself around any information he might share with me, including those slides today. I'd like to have those so I can mull those over and try to figure out where those numbers were harvested from. So I have no reaction. I mean, if the commission feels they can't deliberate today on my application and wants to continue it to another date, I think that's fine, and give me time to talk to staff about it to see if I can understand what they're doing and see what impact that has on my client and his operations. I think that would be most beneficial, and maybe we could then work towards resolving this, perhaps even outside of the commission. I'm not certain if that's a reality, but maybe it is. So I wouldn't be opposing any kind of continuance.
Okay, thank you for that. I would adjust one word within your deliberative comments there, use the word manipulation of the rules, and no one's trying to manipulate anything. We're just trying to apply them in a successful manner. And I think you agree with that, Mr. Willis.
Fair enough.
Yeah. Okay. Deputy Director Cuthbertson, did you have any thoughts about kind of procedurally where we're at and where we may be going?
Thank you, Chair. Again, my apologies for the confusion today. I take full responsibility for it. I would suggest the perhaps best path forward from my perspective is for the director to revise our director's recommendation in this case and more fully explain what we believe a foundation for considerations would be, and provide that to all parties concerned, including Mr. Willis and his client. And then we could have whatever conversations, I'm happy to have whatever conversations Mr. Willis would like to have regarding that information once I'm able to put it together for everybody to see.
Okay. I think we've somewhat reached consensus that the appropriate course is potentially a continuance to allow this matter to percolate a little bit further and the director's recommendation to be revised. I'm comfortable with that approach. Looking to my fellow commissioners if there's some comfort there. Also looking to Hearings Manager Larson in terms of if we do continue, are we continuing it to a date, like I just continue without establishing a new date, or are we continuing it to a certain date? Not sure what our preferred practice there is. Ms. Larson?
So if I may recommend, I think it might be appropriate at this point just to continue it with an undefined date. I'm not quite sure when we will have our revised director's recommendation out, and if there's an opportunity for staff to speak further with Vision about that revised director's recommendation. So that's my best recommendation. We can certainly get this on the agenda as quickly as possible. Since it's already been publicly noticed, we don't have to wait for their 60 days to pass for an additional notice.
That was, I guess, my wonder there. And so if we don't have to do a new notice, I would recommend Commissioner making a motion to continue this matter to continue it without a date set, and then we'll hear it again here in the future.
So moved.
I'll provide a second with one small comment, Mr. Chair. I think this is an appropriate way to move forward with this. I'll say based on the presentation today from the operator, I don't think that they have carried a burden with respect to proving their financial assurance option as presented. And so, you know, I think it's best for all parties involved to try and resolve this outside of the commission. But with that, I'll second.
Okay. With that, we have a motion and a second to continue the matter to a date uncertain. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. Thank you, Deputy Director Cuthbertson, and thank you, Mr. Willis and Mr. O'Hare. We'll look forward to the parties' further work on this matter, and we look forward to seeing it back before us at a date uncertain.
Thank you, Chairman.
Okay.
Mr. Chair.
Yeah, AG Davenport.
Thank you, Chair. I didn't want to interrupt the conversation about more important matters. I did want to clarify something that I may have misstated earlier, and that is, in order for the commission to go into executive session, we need the affirmative votes of 4 voting commissioners.
Okay.
But a quorum is still 3. In other words, in order for this commission to conduct business, we need 3 voting commissioners. In order to go into executive session, we need 4.
Okay. And counting heads, we still only have 3, so we would not have been able to go into executive session today.
Right.
So appreciate that clarification. We don't often have a situation in which we only have 3 of us. With that, let's take a morning break before we pick up our next application and return at 10:17. All right, we are back on our Wednesday, May 10th docket for the Colorado Oil and Gas Conservation Commission. We now will take up our next agenda matter, docket 2211002888, an oil and gas development plan before us. And I see that we have Ms. Wazelinski. Good morning. You and your folks are recognized. If you have witnesses, we might go ahead and bring in AG Davenport and get them sworn in so that we can take care of that and not lose as you present your matter.
Sure. We're happy. Good morning, Chair. Thank you. We do have all of our panelists here. We're happy to swear them in if that's the procedure you want to follow this morning. So just let us know.
Go ahead, AG Davenport.
Thank you, Chair. Ms. Wazelinski, would you have all of your potential presenters visualize themselves, please?
Yes. If all of you could just turn your cameras on. Thank you.
Whole slew of folks, welcome.
Thank you. I'm
what-
counting. Oops, sorry, Mr. Chair. Please go ahead.
No, go ahead. Go ahead.
I think I'm counting 8 people. I'm going to ask each of you in turn to raise your right hand, state your name, and say that you swear to tell the truth. I'll identify each one of you and just work down the row as I see you. So the first person is Ms. Bland. Would you please go ahead?
I just say I do. I swear to tell the truth.
Please state your name and then say that you swear to tell the truth.
Sorry. I'm Jennifer Bland, and I swear to tell the truth.
Thank you, Mr. Knox.
My name is Bill Knox, and I swear to tell the truth.
Thank you. Mr. Tantillo, apologies for mispronunciations.
No problem. My name is Michael Tantillo, and I swear to tell the truth.
Thank you, Ms. Lott.
My name is Whitney Lott, and I swear to tell the truth.
Thank you. Ms. Feister?
Yes, this is Miracle Pfister, and I swear to tell the truth.
Thank you. Ms. Johnson?
My name's Laura Johnson, and I swear to tell the truth.
Thank you. Mr. Bernice?
My name is Galen Brenize, and I swear to tell the truth.
Thank you. And finally, Mr. Calhoun?
My name is Ryan Calhoun, and I swear to tell the truth.
All right. Thank you all. That's everyone I see.
Great. Thanks, everybody. With that, we will look forward to a presentation by the applicant.
Wonderful. Thank you. I'm just about to share my screen and I will get this in presentation mode. Okay. Can you all see that?
Yep, in presentation mode. Looks
Okay,
good.
wonderful. Well, good morning, commissioners. Again, my name is Kelsey Wazelinski, and with Jamie Jost, we represent Anschutz Exploration Corporation in the Coyote Fed 0397-14 OGDP before you in docket number 2211-00288. I'd like just to take a moment to thank Taylor Elm for his efforts on this OGDP on behalf of CPW, and also Moffett County for submitting written comments in support of the Coyote Fed OGDP, and also COGCC staff and the director for their efforts on this OGDP. I'm going to take just a few minutes to summarize the Coyote Fed OGDP and requested relief before I turn it over to Anschutz. This OGDP requests that the commission establish an approximate 3,840 acre OGDP for the development of 6 new horizontal wells in the Niobrara Formation. The Coyote Fed OGDP also requests that the commission approve 1 new Form 2A for the new Coyote Fed 0397-14 pad for the development of 6 new horizontal wells. Both the proposed surface location and mineral development are located within the 22,960 acre Wiley Federal Exploratory Unit. Due to federal unit requirements, the mineral development area for this OGDP is subject to a future BLM paying well determination. However, the OGDP application defines 6 sections of anticipated mineral development for this OGDP, which is subject to the BLM's confirmation after the wells are drilled and producing. The Coyote Fed pad is located within Moffett County and the mineral development area extends south into Rio Blanco County. Moffett County waived its siting authority for oil and gas locations. However, Anschutz has been in close communication and consultation with Moffett County throughout the OGDP process and has also discussed the proposed haul routes and associated road maintenance with Rio Blanco County. The proposed Coyote Fed location triggers 2 Rule 304 ALA criteria. It's immediately up gradient from a mapped wetland, and it is within several high priority habitat. It's within a Rule 1202C aquatic sport fish management no surface occupancy buffer, which CPW has waived, in addition to several big game high priority habitat and the greater sage grouse general habitat management area. Anschutz will describe its extensive consultation with CPW for the Coyote Fed location and the 3 proposed alternative locations, CPW's waiver of the aquatic sport fish management NSO, and CPW's conclusion that the Coyote Fed location is protective and implements the mitigation hierarchy to avoid, minimize, and mitigate impacts. As part of the Coyote Fed OGDP, Anschutz has committed to several BMPs to avoid, minimize, and mitigate potential adverse impacts, which Anschutz will describe today. And finally, Anschutz has complied with all notice requirements for the Coyote Fed OGDP. No formal petitions were filed and no public comments were received on the Form 2A. So with that, I'm going to turn it over to Jennifer Bland, who's the project manager for Anschutz, to continue the presentation.
Good morning, commissioners. My name is Jennifer Bland, and I am the project manager for Anschutz Exploration Corporation. I appreciate the opportunity to present the Coyote Fed OGDP to you today. I'll provide an overview of Anschutz, the proposed surface location for the Coyote Fed OGDP, and an overview of our proposed development and siting considerations, including our engagement with CPW and our alternative location analysis. Anschutz Exploration Corporation is a private, independent oil and gas company with assets located in the Piceance Basin of Colorado, Uinta Basin of Utah, and Powder River Basin of Wyoming. Along with myself and Ms. Wazelinki, we have several subject matter experts on hand from Anschutz to address any potential questions the commission may have. The Coyote Fed oil and gas location is located within the Wiley Federal Exploratory Unit and will be used to develop 6 new horizontal wells for development of the Niobrara Formation. While Moffett County does not regulate the siting of oil and gas locations, Anschutz has consulted with Moffett County prior to filing the Coyote Fed OGDP and will obtain all required pre-construction administrative permits as needed. The Coyote Fed location triggers 2 Rule 304B2 criteria. First, the location is immediately up gradient from a mapped wetland. I will describe the proposed BMPs on the Form 2A to ensure that the appropriate protections considering the proximity to the wetland, including stormwater BMPs and secondary containment. Second, the location is within the Rule 1202C aquatic sport fish management no surface occupancy buffer. CPW agreed to waive the NSO stipulation, which I will expand upon later in the presentation. The Coyote Fed location is located within several big game winter ranges, but does not trigger Rule 1202D density HPH because it is the first location with within 1 square mile. However, Anschutz consulted with CPW and BLM and has agreed to timing stipulations and compensatory mitigation, which I will also describe in more detail. Ultimately, CPW has determined that the proposed Coyote Fed location is protective and implements the mitigation hierarchy. The Coyote Fed location is not within the ozone non-attainment area, and there are no residential building units or schools within 2,000 feet of the oil and gas location. Finally, Anschutz does have a surface use agreement in place with the surface owner. I would like to give a brief overview of the Wiley Federal Exploratory Unit, which is shown here on this map outlined in blue, and the anticipated mineral development area for the Coyote Fed OGDP shown in red. After each of the 6 proposed wells is drilled and completed, Anschutz will make an application to the BLM for a paying well determination. If the wells are determined to be paying wells by the BLM, then the wells will be subject to the Wiley Unit and Wiley Unit Agreement. If the wells are not determined to be paying wells by the BLM, then Anschutz will apply for a spacing order from the COGCC. This slide highlights the relevant timeline for the Coyote Fed OGDP. Anschutz consulted with the BLM and CPW on site in May of 2022 and conducted the pre-application consultation with Moffett County in August of 2022. Anschutz complied with all required application notices and public comments were submitted on, and no public comments were submitted on the 2A and no petitions were filed. If we receive approval of this OGDP, Anschutz will submit the corresponding Form 2s for the Coyote Fed location and plans to commence construction in July of 2023. Once we receive the approved Form 2s for the Coyote Fed OGDP, Anschutz intends to develop the exploratory wells and 2 drilling occupations. The first is anticipated to commence in September 2023 with completions in November of 2023. The second is anticipated to commence 1 year later in July of 2024 with completions in October of 2024. Based on our consultations with the BLM and CPW, Anschutz agreed to limit its drilling and completion activities to avoid the big game winter season and the sage grouse nesting seasons to the greatest extent possible. These are reflected on the Form 2A. CPW has expressed support of this plan because it is the most protective of sage grouse, which is the most sensitive species in this area. As I mentioned, the proposed Coyote Fed location will include new ground disturbance within Rule 1202C NSO for sport fish management waters, Rule 1202D big game habitats, and the greater sage grouse habitat management area. The map on this slide shows each of these habitats per the color-coded legend, with the direction of the elk, mule deer, and pronghorn habitats indicated by the direction of the arrows. I will reiterate that the location does not trigger Rule 1202D because it is the first proposed location within 1 mile. However, Anschutz consulted with both CPW and BLM and has agreed to the timing stipulations for both big game habitats and sage grouse. As I will describe in more detail in the next few slides, CPW extensively reviewed our ALA analysis and agrees that the proposed Coyote Fed location is the most protective alternative to protect wildlife. With respect to the sport fish management NSO, which is shown as the darker blue line on this map, CPW agreed to waive this NSO for 3 primary reasons. First, CPW concluded that the waterways are ephemeral in nature and do not contain adequate flows to support any sport fish populations. Second, based on feedback from CPW biologists, CPW concluded that the waterway is too far from the White River to be seasonally important for any native fish species that often use ephemeral drainages for spawning activities during spring runoff. And third, CPW acknowledged Anschutz's agreement to implement BMPs recommended by CPW to avoid and minimize any potential adverse impacts to this waterway. As part of our consultation with CPW also waived the 500-foot setback for fuel tanks and chemical storage facilities from ephemeral and intermittent streams. With respect to the sage grouse general habitat management area and sage grouse priority habitat area, shown on this map in light and dark pink respectively, Anschutz agrees to pay the BLM mitigation fee to CPW to mitigate any potential impacts to the sage grouse. The BLM does not have a mechanism to accept mitigation payments and agreed to utilize CPW's mitigation account for sage grouse mitigation. Because Anschutz will be mitigating its impacts to the big game as well, Anschutz, CPW, and the BLM agree to utilize this one method to complete both state direct impact obligations and federal indirect impact obligations. In addition, CPW and the BLM intend to enter into a memorandum of understanding to outline how these mitigation funds will be used to implement or will be implemented to offset impacts to greater sage grouse habitats. As a result of our extensive consultation with both CPW and the BLM, CPW issued a written wildlife determination summary on February 14th, 2023, which concludes that the OGDP application is protective of the wildlife resources and implements the full mitigation hierarchy. In addition, CPW recognizes the benefits of 2 drilling occupations to minimize impacts during sensitive wildlife time periods. CPW concludes that it does not have any objections or outstanding issues with the Coyote Fed OGDP application. Moving on to ALA, we considered 3 alternative locations in addition to the preferred Coyote Fed location. All of these were reviewed by CPW. The preferred location, as well as alternatives 1 through 3, are shown on this map. Alternative 1, just to the west of the Coyote location in section 15. Alternative 2, just to the north of the Coyote location in sections 10 and 11. And alternative 3 is shown to the southeast of the Coyote location in section 25. In evaluating the alternatives, it's important to note that the only location that can reach the targeted minerals without creating significantly more disturbance is the proposed Coyote Fed location. CPW staff reviewed the Coyote Fed location in person during an on-site consultation and determined that the Coyote Fed location allows for Anschutz to avoid and minimize overall direct impacts to suitable sage grouse habitat. CPW also agrees that the Coyote Fed location is the best alternative from an overall wildlife perspective. In addition, CPW reviewed 2 possible access road alignments for the Coyote Fed development and concluded that the alternative alignment passed through the 1 mile buffer of an active sage grouse leg and would be more impactful since grouse are the more sensitive species in this area. And CPW ultimately prefers the proposed access road alignment. In the next few slides, I will talk through alternatives 1, 2, and 3, and why the proposed Coyote Fed location is the most protective location while still accessing the targeted minerals. Alternative 1, shown here on this map, has challenging topography, which would allow for the development of only 3 horizontal wells compared to the 6 wells from the Coyote Fed location. In addition, the pad is located on a ridge with steep slopes and drainages that could impact a potential wetland near the pad and an intermittent stream. Alternative 1 is also located in multiple HPHs. And during the on-site consultation with BLM and CPW, both agencies suggested dropping alternative 1 in favor of the proposed Coyote Fed pad. Alternative 2, shown here, also only accommodates 3 horizontal wells due to the challenging topography of this location and could impact a potential wetland due to the steep slopes and drainages of this location. This alternative is in the middle of sections 10 and 11, requiring either drilling long portions of non-productive laterals or shortened laterals. Alternative 2 is also located in several high priority habitats. Furthermore, this location may be very challenging to tie into existing oil and gas infrastructure. For these reasons, Anschutz decided not to pursue alternative 2. Alternative 3, shown here, also only accommodates 3 horizontal wells because the additional 3 wells do not meet federal exploratory unit requirements and would penetrate unleased federal minerals. There is a potential wetland to the east of this location, down gradient from the pad, and the location is within multiple HPHs. For these reasons, Anschutz decided not to pursue alternative 3. Ultimately, Anschutz is pursuing the proposed Coyote Fed, which allows for the development of 6 2-mile horizontal wells, has favorable topography, avoids additional disturbance, and has assigned SUA. We can also tie into other oil and gas development infrastructures, and it is supported by CPW and the BLM. I will note that while the proposed Coyote Fed location is within greater sage grouse priority habitat, it is unfavorable habitat as determined by the CPW. This slide shows how this proposed Coyote Fed pad meets the avoid, minimize, mitigate hierarchy as acknowledged by CPW. The location avoids all residential receptors, is in unfavorable sage grouse habitat compared to the other alternatives, has a less impactful access road alignment, and will adhere to timing limitations to avoid big game winter season and sage grouse nesting season. The location minimizes impacts by Anschutz's commitment to spill prevention and stormwater containment BMPs, remote monitoring and remote shut-in technology, secondary and tertiary containment measures, siting of tanks away from drainages, and the staging of emergency spill response kits on location. The location mitigates potential impacts to the HPH by implementing timing stipulations, compensatory mitigation, and best management practices, best management planning guidelines set forth by the BLM and CPW. Also, stormwater BMPs will mitigate any impacts to the drainages, including secondary containment and placement of tanks 500 feet from drainages. These next few slides will highlight a few of the protective BMPs specific to wildlife on the proposed Coyote Fed Form 2A. This slide highlights the BMPs specific to sport fish management waters. Though the CPW has determined the habitat surrounding the Coyote OGDP to be unimportant for native fish species, Anschutz will construct line containment around storage tanks and locate the facilities on the portion of the pad furthest from the Deep Creek channel. To protect big game and sage grouse habitats, Anschutz will avoid construction, drilling, and completion operations between January 27th and April 30th for big game winter season, and between March 1st and July 15th for sage grouse nesting season. Anschutz has also committed to multiple BMPs to mitigate potential noise impacts. Next, I will be walking through the BMPs associated with the various phases of development, but for the sake of time, I will only touch on a couple points on each slide. With respect to construction, Anschutz will restrict construction on high wind days and ensure stormwater control measures are in place during all phases of development. With respect to drilling, a temporary impermeable liner will be used under the rig, and fluid storage tanks will be equipped with level indicators and routinely checked. With respect to completions, all water will be transferred to location using a lay flat line to reduce truck traffic. In addition, a multi-well zipper frac will be used to increase efficiency and reduce duration of completion. And finally, with respect to production, produced water will be transported using produced water pipeline to reduce truck traffic. The well site will also be automated with PVT monitoring equipment to recognize any upset conditions and remotely shut the wells in. With respect to infrastructure, at the commencement of production operations, gas will be directed to a gas gathering system. All produced water will also be connected to produced water pipeline to be constructed adjacent to the access road. Because this is an exploratory development in a remote area, oil will be stored on site and trucked off location daily. The closest existing oil takeaway is more than 15 miles from this OGDP. The map on this slide shows the proposed haul route within Moffett and Rio Blanco counties. As I mentioned earlier, we have been in close communication with both Moffett and Rio Blanco counties on road maintenance. Anschutz intends to evaluate the production from the wells drilled under this OGDP to help determine the scope of the potential future oil infrastructure needed for this area. The Form 2A also contains several BMPs to mitigate traffic and dust impacts from trucking produced oil. I will briefly touch on the community outreach. As I mentioned, this location is in a remote area of Moffett County, and the closest RBU is greater than a mile from the proposed Coyote Fed location. We do have an executed surface use agreement with the surface owner for the location, and both Moffett County and Rio Blanco counties are aware of our proposed development schedule. We will continue to work with Moffett County to ensure that we have necessary county administrative permits in place for the Coyote Fed location. I will now turn the presentation over to Ms. Wazelinski to summarize and conclude.
Thank you, Ms. Bland. To summarize the Coyote Fed OGDP and request for approval, we note the following OGDP highlights. No petitions were filed to the OGDP, no public comments were submitted, and Moffett County supports the development. CPW also deems the Coyote Fed OGDP adequately protective of the wildlife resources present in the area of development and agrees that the proposed location is the best alternative from a wildlife perspective. The director also recommends approval of the OGDP. And finally, the siting and BMPs provide protection of public health, safety, welfare, the environment, and wildlife resources by avoiding, minimizing, and mitigating adverse impacts. And this last slide is again just a summary of the requested relief. We respectfully request approval, and we've got a team of subject matter experts here, and we are now open for questions. And I'll stop sharing.
Great. Thank you for the presentation. Commissioners, the panel is open for questions. Commissioner Messner.
Thank you, Mr. Chair. Thank you for the presentation and the application. I do have a few questions. One, I wonder if someone could talk a little bit about the process that's underway with the BLM. Talk a little bit about the exploratory nature of the application and what ultimately, should things be successful there, may be contemplated either through the BLM's Wiley Unit Agreement or other federal processes, and or what you all may see as the future of this particular area, should this project be approved and end up being successful.
Thank you, Commissioner Mesner. I'll maybe start on the process, and then I may have someone at Anschutz kind of describe the development potential of the federal unit. But from how I understand it, Anschutz will make an application to the BLM for a paying well determination, and that essentially involves evidence of revenues from production, and if they exceed the costs over a reasonable period of time, they would get that paying well determination, and would not need to unitize with the commission. So once that determination is made, then Anschutz would apply for the participating area, which would cover the area reasonably estimated to be drained by the well. And that's the same as a communitization agreement. So that's kind of a process description. And maybe, someone from Anschutz can speak on the development potential within the entirety of the federal unit, if I understood that question.
Sure. I will talk a little bit about the future of the location. So per the Wiley unit agreement, we are required to drill 2 wells per year, stepping out as development occurs. And yeah, as Kelsey described, the paying well determination, the BLM will just evaluate those locations. We actually currently only have 3 horizontal wells in this formation in this immediate vicinity. So we're it is an exploratory play, and we're hoping for success.
Thank you for that. I wonder if you could talk a little more about, the process that's happened with the federal permit reviews, and whether there's been a NEPA done or whether the NEPA is in process, and kind of the disposition of the conversations that have gone between the permitting process with the federal agencies, as I find it relevant as we coordinate our regulatory procedures between the federal government, local governments, as well as the state.
Absolutely. So the BLM, the White River field office, has been involved in this from day one. They've been on all of the on-sites that CPW attended, and we have APDs pending in their office currently. They are in the middle of writing the NEPA document for this location. It is pending a cultural piece that they are evaluating now that the snow is gone. But all feedback from the White River field office is that these APDs will be approved. They have no concerns that they've stated so far, and are supportive of all the mitigation that we have offered up.
Okay, thank you for that. So I wanted to talk a little bit about the different BMPs that are being considered for wildlife. And it's clear that there's been significant coordination between CPW and the applicant as far as developing different strategies to meet the obligations of the mitigation hierarchy. But we still have a situation where we've got no oil takeaway, and so that there will be some amount of truck traffic associated with that. And so I wonder how the applicant and or the conversations with the BLM occurred as far as how to avoid, minimize, and mitigate impacts to having to haul oil off-site on a daily basis through high priority habitat.
So I'm not exactly sure how to answer that. The BLM has not disclosed a major concern with the truck traffic, understanding that it is an exploratory development and this is just where we are. Actually constructing the pipeline at this point in time without knowing what scope that needs to be and what type of development this may turn into probably isn't the right call. So just maintaining the haul routes, we're sticking to one haul route out of the field, mitigating dust impacts and avoiding sage grouse lags. They have considered those to be satisfactory BMPs at this point. As development occurs, we are, and actually even today, we are evaluating options for oil takeaway. And those designs and the development will be weighed against each other, and ultimately a line will be identified and constructed once we know what the scope of the production is.
Commissioner Mesner, I may just add, many of the discussions with CPW in particular were on protecting kind of the more sensitive species from a development timeline standpoint. And actually doing 2 occupations did alleviate a lot of concerns to protecting kind of the most sensitive sage grouse development timeline. So I did want to just mention that a lot of the discussion on avoid, minimize, mitigate were on phases of operation and trying to do the most impactful activities outside of the most sensitive timeframes.
No, and I appreciate that. And I definitely saw that in the documentations that were provided with the application. What I didn't see was any kind of conversations around whether or not timing STIPs would apply to the truck traffic associated with oil takeaway. And so I'm assuming that is not the case. And so trying to understand any kind of impacts that were considered around the truck traffic associated with having to haul oil away, and understanding that there is habitat fragmentation and impacts to species associated with roads and truck traffic, and not just construction activities. So anyway, I was just curious as far as what conversations occurred around that. There was also some discussion, at least in the director's recommendation, around a possible requirement for Army Corps of Engineers 404 permit for road construction, and I was just curious where we're at today on that.
The wetland mapping was completed just a few weeks ago and confirmed that there is no section 404 permitting required.
Okay. That's the questions that I have at this point. So thank you for answering my questions.
Good questions. Thank you, Commissioner Cross.
Thank you, Mr. Chair, and thank you very much for the presentation today. I appreciate the thoroughness of it. I guess to start off, I'll ask one follow-up question based off what Commissioner Messner was asking about with respect to the NEPA process. Do you know if there was public comments filed on the draft EA for this?
To my knowledge, it's not been issued for public comment, as they're still waiting on a cultural resources piece to be finalized. I expect it will be published within the next 30 days.
And will that be the draft of it? Will that be the final? Is it a determination of adequacy, a DNA? Do you know what the?
It will be an environmental assessment, an EA, and it will be posted for 30 days for public comment. So to date, there have been no public comments filed, but there will be an official comment period, in about a month.
And do you anticipate any changes to your schedule should there be any kind of delays with respect to public comment or anything like that?
Obviously, we won't be able to start construction until the BLM APDs are approved. Currently, we are planning to start mid-July, which is when this sage-grouse STIPs lift. The BLM is working with us to try to meet that target timeframe. However, if there is some public comment that delays that, obviously we cannot start until BLM approves it.
And with respect to the mid-July STIP being lifted, I know that there's still migratory nesting bird stipulations that last past that. Given the stage that you won't be able to go in and do any kind of pre-activities on the site before that ends, because the timing STIP, we're already in the middle of it. Are there planned surveys to occur before any construction begins with respect to the migratory birds as well?
Absolutely. We do plan. We've been told that it's unfavorable habitat, but we have committed to conducting those ground nesting surveys prior to construction while that STIP is in place.
And then the one other question that I wanted to ask about was, I know there's been some flooding in Moffat County recently with the snowpack melt. Do you know if this area has been affected by the flooding at all?
To my knowledge, it has not. We've heard that the snow has recently cleared and the ground is drying out, so no flooding concerns in this area.
Okay. Thank you. That's the only questions I have right now.
Any questions? Further questions for the panel? Commissioner Messner?
Thank you, Mr. Chair. Just a follow-up. So I'm just trying to understand. I mean, my understanding is, and I just want to make sure that the applicant agrees with what I'm about to say, is that the timing steps as presented in the 2A and then affirmed in the presentation here today do intend to be followed irregardless of the timing associated with the federal review process. So my point being, if the federal review process is delayed in its decision for whatever reason, and the construction timeline would not be able to be adhered to, the timing steps would still be adhered to, understanding it may delay the process on this particular application. Is that my understanding?
That is correct.
Okay, thank you.
Great. Anything further for the panel? Very good. We would move into deliberations. Commissioner Messner.
Thank you, Mr. Chair. Yeah, I do think that this is an approvable application. I appreciate the work that's been done by the applicant in coordinating with the Colorado Parks and Wildlife and other entities in developing the application and developing the project. I thought that the alternative location analysis was well done. I wished that I would have been able to see a closer coordination between the COGCC and the federal agencies in review, because it does benefit me to see some of the information that's provided in the NEPA analysis in my review. I understand that it's not required and that we independently review these permits. But I do find that coordination and that communication between the federal process and the state process certainly helps me better understand the project and better understand and coordinate any sort of BMPs or COAs that may be incorporated in an application. And so, I do think it ultimately benefits the operator to do that as well, because inevitably, if there's a significant change associated with the federal process, it would have to come back then through the COGCC process, depending on what ultimately that change would be. However, I think as presented, it is an approvable application. Understanding that this is an exploratory process and currently there's no consideration for oil takeaway, I do think that in this particular application is appropriate. I think if there were future applications that came before this commission expanding this particular area, that would cause more concern for me as far as potential impacts in multiple high priority habitat areas. And so just a thought on that I would hope that should things be successful here and things move down the process in this particular area, that consideration be given to developing fully the infrastructure necessary to avoid, minimize, and mitigate impacts to wildlife and high priority habitat areas. But again, I think it was an organized application, and appreciate the work that was done with it, and appreciate the coordination that was associated with it. And so I will be voting in support of this application.
Mr. Cross.
Thank you, Mr. Chair. I will just second Commissioner Messner's thoughts. I thought that this was a very well done application, very thorough, especially with respect to the numerous wildlife receptors within this region. I'd also like to provide a shout out to the thoroughness that CPW had with respect to their write-up and explanation of their decision. That was very helpful as well. So with that, I don't know, Chair, if you'll have comments as well, but I would move for approval of this application.
Great. I'm in agreement as well. We have a motion. Do we have a second?
Second.
Motion and a second. Is there further deliberation or thoughts from commissioners? Seeing none, all those in favor of the motion signify by saying aye. Aye.
Aye.
Any opposed? Motion carries. OGDP is granted. Thank you, Ms. Weslinky, and to all of your panels.
Thank you.
All right. With that, my fellow commissioners, it looks like the next contemplated action item is a motion to adjourn.
So moved.
Second.
Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
Great. Good work, everybody. We'll see you soon.